So the hearing itself. Based on the evidence presented, the judge will decide on whether the respondent needs a full or limited guardian and conservator. We talked about testimony. The judge will consider if the respondent is capable of living independently, if they can take care of him or herself, capable of driving, voting, and can take care of their own finances. Obviously, these are all at the crux of these matters. There are three specific questions I always have to ask the petitioner. Do they feel that the respondent has the mental capacity to safely operate a motor vehicle, to participate in the voting process, and to marry? So very often I'll have parents that say, I want my child to be able to drive, but I don't think right now they're ready. And so I literally just petitioned the court for a guardianship that I did last year where the parent said, our son is doing great. His physician feels that he can take the driving exam. And so we provided the physician letter and asked the court to allow him to take the test to obtain his driver's license. And he did. Voting is usually retained for someone because that's not usually a big issue. The right to marry is significant because it is a contract. So it's not just a social and interpersonal endeavor, it is a contract financially. So that too may be something that comes up later in life. And the issue is sometimes guardianships and conservatorships can be reversed. So if somebody develops the social skills or the financial skills to be able to create durable powers of attorney, and they're no longer incapacitated and disabled, we can undo this process. It's called restoration. And that is a wonderful day. All it requires is a physician, again, filling out an affidavit that basically asks the questions in reverse. And we provide that to the court, and we have a hearing, and the court essentially asks questions of the respondent. And there are times when somebody can be restored. The burden of proof is always on the petitioner to show that the respondent is incapacitated or disabled, either in a limited or full capacity, and that a limited or full guardian conservator is needed. The petitioner calls witnesses first. The guardian ad litem, or the court-appointed attorney, may cross-examine the petitioner and witnesses. After the petitioner presents their evidence, then the court-appointed attorney gives his or her report based on their meeting with the respondent and the petitioner, and the respondent may make a statement or testify in court, and the judge will make its ruling. So what's the effect? The rights that are relinquished or limited or suspended completely are the power to consent to or refuse medical care, the right to vote unless a request is made and the court preserves that right, which again is really pretty much freely given, the right to marry without a guardian or court permission, to enter into enforceable contracts, which really very often is the basis for why somebody may want a conservatorship, and the right to obtain a driver's license. And how does a guardian or conservator prove their authority? The court will issue letters of guardian and conservatorship, an actual legal document that the guardian and conservator will then provide to physicians, other healthcare providers, and financial entities. The letters identify whether the person has limited or full authority. There's only one original, one gold stamped document that's issued, and I usually advise my clients to obtain multiple certified copies, which I can order for them. So the duties of the guardian are to assure that the ward lives in the best and least restrictive environment that is financially feasible. The guardian and conservator are not required to spend their own money unless we're talking about a parent that for some reason needs to be guardian for a minor. But that really doesn't happen that often at all. They have to assure that the ward receives the needed medical care and services. They can require that. And for my clients who have mental illness, this is when it's very stressful, but there are some times when the court-appointed guardian must call the Crisis Intervention Task Force officers to take someone to the hospital to receive treatment. For example, those individuals who receive an injectable antipsychotic. The guardian must promote and protect the care, comfort, safety, and health and welfare of the ward and provide required consents on behalf of the ward. And on an annual basis, the court will send them a 2-page report that asks, where's the ward living? Where's the guardian living? The guardian has the authority to move the ward without court pre-approval because they have an ethical duty and a legal responsibility to ensure that the ward is in the most appropriate, least restrictive living environment commensurate with their needs. And so the court does not want to impede that, and they allow the guardian to move someone freely. So the guardian report asks, what is the care plan, if that's appropriate for the individual? Do they still need a guardian? Kind of what they're doing with their day. And it's a very straightforward form to submit to the court. The conservator duties are definitely more administratively burdensome. They must account to the court for all of the protectee's income and assets. That is the initial filing, that when a conservator is appointed, that we have to, as an attorney, file to the court explaining any assets and income that is in the respondent's name. I forgot to mention, if only a guardian is appointed, you do not need to continue to have an attorney. If a conservator is appointed, there needs to be an ongoing attorney involved with the case because it is only the attorney that can file the ongoing petitions asking the court for approval. So we have to first file an inventory that explains to the court all the assets and income in the individual's name. The conservator has to ensure that the protectee's needs are paid for, but again, only with court approval. All expenditures over $100 and any sale of property that is in the name of the respondent must be pre-approved by the court. So when we file the inventory, we shortly thereafter file with the court what's called a request for a monthly support order. So if there are regularly occurring expenses, so for example, if someone is living in a facility, whatever the facility costs are, clothing, meals, medication, discretionary spending, we put together essentially a budget and ask the court to pre-approve the budget for the conservator, and the conservator must stay within those limits. If there's an emergency, so for example, if someone breaks a molar and has to have an emergency dental procedure, the conservator can pay for that because they will have access to the conservator account, but then they'll have to come back to me and ask me to file a petition to ask the court for ratification, to approve something that's already been paid for. At the end of each year, that's coincident with the date of appointment, we have to file what's called an annual settlement, explaining to the court every single expenditure with all receipts and all bills that have been paid and all evidence of income. So it's quite a process, but I ensure when I'm working with a conservator that every month they send me the conservator account statement that has been opened by them by giving the letters of conservatorship to whatever bank they open this account with, that shows me that they're following the monthly support order, that they're paying the bills that we explained to the court we're going to come in, and show me the evidence of payment. So each month we build this annual settlement so that by the end of the year, it's really all put together. So, any questions?
Okay, one is what kinds of questions do you usually ask the parent who testifies?
Oh, after kind of the perfunctory name, address, how are you related to this individual, to ask them why they're seeking to be appointed guardian and or conservator. And often the response is, and I coach the parents. I mean, I meet with them before the hearing for sure, and talk to them about, is there a diagnosis? What is your son or daughter capable of doing? Are they capable of handling their own personal hygiene? If so, do they need prompting? Do they need actual assistance? What kind of assistance? Do they need hands-on assistance? Can they take medications independently? Do they need prompting with that? Do you need to stand there and watch them take the medications? Are they capable of dressing in a weather appropriate manner? So, kind of going through all of the activities of daily living to give the court a really complete picture of the scope of authority that the guardian needs to have. Because sometimes, again, somebody's completely capable of taking care of all their personal care needs, but they can't take medication themselves. They wouldn't know how to call and make a doctor's appointment. So it really depends upon the abilities. And then certainly the same types of questions regarding money. Is the person able to make change? Things of that nature.
And this is a great follow-up to that same type of question. So who prepares the individual for the court process? Would you
Me?
also do that? Yeah. And
Yeah.
then will they be asked questions on the stand, or does their attorney answer questions on their behalf?
No. So I ask you questions and you give me answers, and we'll talk about this when we prepare for the hearing. Basically, keep it short and sweet. And you maybe ask questions by the court-appointed attorney. So I will often and again, this is not adversarial unless someone challenges it. And if that happens, we'll have ample time to prepare.
So someone else says this is a required process for the individual, yet the petitioner pays the cost. What if they literally can't afford it? Either party can't afford it, but we're being told we have to do this.
Hmm. There are some attorneys that will do this for free. I mean, again, there are times when I will do it in conjunction with Legal Services of Eastern Missouri or Easter Seals or some other nonprofit organizations that contact me and say that they have a client that really cannot afford this. And again, the court-appointed attorney, if the respondent does not have assets in their name and only receives SSI, that attorney's fees are paid by the county.
Okay, someone's asking about the judge. They want to know if the judge has been doing this a long time and is likely to have great experience with this population typically.
Yes. Yes. Because it is not the chief judge of the probate court that handles these, because those individuals change the divisions they work in every 4 years. But the probate court commissioners are usually there for decades. So really all of us, again, the probate court is more of an intimate, very subject limited court. So everyone that works in the probate court, the staff, the commissioners, the attorneys, all understand all of these issues and are usually really compassionate and have a lot of experience.
This person says that they've had a hard time assisting their son with voting. They said, we do the practice ballot that he takes with him, but he typically needs to ask me for some help as he gets very nervous. Even though he retained his right to vote, I get a lot of negative looks while helping him vote. People have even made comments about me influencing his vote. Can we just do absentee voting for him due to the negativity from the public?
I was just going to suggest that. Yep. Mail in or absentee.
And I'll just add too that there is a way to get a permanent disability voting status so that you always get your ballot
Yes.
by mail. And there's also curbside voting in St. Louis City and County, if that is helpful at all. And that's, typically I would say for people with a physical disability to use so that they don't have to go in. But I mean, they're not checking why you need curbside voting. So just putting
But I
that
do
out.
understand the looks that you can get.
Yeah, that's really tough. And
It's
you
really hard.
are allowed to assist someone.
Right.
They can
Absolutely.
decide that they want assistance for voting, but that's unfortunate that the public does not always understand what's going on. Okay, we have 3 more questions. Do you want to just keep going with the questions? Okay.
Let's do questions. I'd much rather do questions.
Okay, great. What happens if the respondent is questioned by the guardian ad litem and the respondent denies they have a disability? and do not want a type of guardian, even limited, especially if the disability is a mood disorder, ODD, anxiety, something like that.
It happens all the time. Happens all the time. And that's when we really try to put together a limited guardianship so that the guardian is kind of standing in the background if needed and can exercise the authority as much or as little as it's needed within those parameters. But it's not unusual at all for somebody to object to it, to state that they don't believe this is needed. Yeah.
What if the individual does not use words to communicate when you're meeting with them?
That's fine. I mean, I've literally met with people that are in a coma all through, I mean, to every breadth. It's because part of it is my responsibility to try to communicate with them in a manner that they will understand, but that may not be possible. But I at least have to try. And in those cases, I take the cues from the parents.
Mm-hmm.
But there are many times when someone just won't understand. And that's part of my report to the court. That I met with the individual and tried to explain to them in a manner in which they would understand, but it was not clear to me that they did.
If the individual does not use words to communicate, can the parent be in the meeting with the attorney, or is that not allowed?
Um, it's usually not allowed, because I need to at least try to communicate with them alone. So if it's a matter of the individual not using words or speaking, if there are other ways in which they communicate that the parent can explain to me so I can try to have a meeting with them alone. If not, then yes, I will meet with the parents and the adult child. Removal and successors. An appointed guardian conservator, we talked about this a little bit, may be removed by the probate court if there's evidence of abuse, malfeasance, neglect, or inappropriate management of personal or financial affairs. But again, the standard for that is very high. Not insurmountable. I've done it many times, but it's very high. If a guardian or conservator passes away, is unable to continue to serve, or is removed, another interested party may petition to be appointed successor, guardian, and conservator. And in that instance, once there's already been a finding of incapacity or disability, and so long as that hasn't changed, the appointment of a successor, guardian, or conservator is easy because the court may require just having a phone call or a meeting or nothing. It's so long as we have that baseline finding by the court and there's been testimony and evidence that the person needs a guardian or conservator. And again, the public administrator of the county may serve in the interim and may become successor if there's no interested party that petitions to be appointed. So a standby guardian can be nominated by a custodial parent for a minor or a disabled adult child in writing that is witnessed and notarized in a will or other writing. And so very often when I prepare estate planning documents for people, when they have young children, or if they have an individual, an adult child that has a disability and may possibly need a guardian or has a guardian, I ask the parents to include in their will, literally all their documents, their durable power of attorney for healthcare, their durable power of attorney for financial matters, and their will, who they would want the guardian to be. A standby guardian may act if a custodial parent is incapacitated or dies. The issue is if the non-custodial parent is still fine, the court will always defer to a non-custodial parent if there's been a divorce, so long as that person's parental rights have not been removed or relinquished. A standby guardian must notify the court within 10 days of beginning to serve and may be appointed by the court with or without a hearing. But within 60 days, the standby guardian has to file a petition. So let's talk about the most common type of trust that arises in this situation. And this is called a special needs trust. And many of you may have already heard about this, and I can certainly do another presentation because this is a presentation all unto itself. This is a wonderful federal law that enables an individual who has a disability to have money maintained in a trust for them and allows them to simultaneously become eligible or maintain eligibility for means-tested public benefits such as Medicaid or SSI. And so very often when a family comes to me and says, we have an adult disabled child that, has, $40,000 worth of stock in their name from their grandparents, we will initially petition for the appointment of a conservator, but say we're asking in lieu of the appointment of a conservator for the court to allow the establishment of a special needs trust. Because again, if you have a trust, you don't need a conservator. So it's something that's allowed under the law so that we can avoid a conservatorship because it's number one, if you have someone who has assets in their name and needs Medicaid or SSI, a conservatorship will not enable them to qualify. So we have to have a special needs trust. As long as someone is under the age of 65, any assets in their name, we can petition the court, asking the court to allow us to create a special needs trust. The court would have no authority over the special needs trust or other trusts for that matter. Now, if it is assets that are in the disabled individual's name that is used to fund the special needs trust, and that individual receives Medicaid, after they die, if there are still funds in the trust, there is the requirement of a Medicaid payback because the trust itself has to have language that says if there are remaining funds and this individual has been a Medicaid recipient, the state Medicaid agency has a first claim at any of those assets. So there are different types of special needs trusts. So those of you that want to leave an inheritance to a child who has disabilities needs to talk to an estate planning attorney, such as myself, to talk about creating a third-party special needs trust with your assets where there's no Medicaid payback. And again, this has to be a whole separate presentation because this is much more complicated. So again, if somebody is receiving only Social Security, the conservator can petition and can ask to be appointed representative payee with the Social Security Administration, which would then end the conservatorship if that's the only source of income.
So the last question I have right now is if we believe a limited guardianship will be necessary for our child when they turn 18, they're currently 16. At what age should we meet with the lawyer to start that process?
Sure, great question. So if you contact an attorney, probably 4 to 6 months before your child turns 18, we cannot file until the day of their 18th birthday. I don't know why the court does that, but they do, which I realize makes parents really nervous. It's like there's going to be a gap. But so we file on the 18th birthday, but we can get everything in place up to then. And if something happens, which I had happen, somebody had acute appendicitis. While we were waiting for the hearing, we literally petitioned the court for an emergency guardianship, and within hours, they were able to do something.
And have a wonderful evening. Thank you so
Yeah.
much for joining us today.
Bye-bye.